What to the boss? As I say, why, wabojuma.
So we pass the sound adwin there.
That is a wada. La.
Okay.
Yet a AG any Dr. Kessel at Forson issue no. Kaku PM wo court e ma ho nsensem ahodo bebre bai. Ye be hu plea negotiation e ho nsensem. Ye be hu leak video correction ho nsensem. Kopko PM say mistrial e ho nsensem e bai. Ni nyina nkamfo a my education kakra emfa ho.
Yo me that say. Even check Ghana this year wajibre 80 usabri. Na yen check Mr. Kwabna Kessy aka Stephen Boatin Esquire is a senior legal practitioner. Kakra or dressing out Shana and Onyaji. And the bra kwame no bibia or shayty and pay. It's been a while or morning like this.
Pa. Me across Lucia ya pa. Fi baby.
What I mean, what's up dodgy because we do
Anyway.
Okay, the echo so no say eye say ene public no e de won ani edi ensema echo so e wo court na chi me ne ana e ba first request bi I free Dr. Kessel to force no no abo say na enkebe ya chief justice say ma kwanya na TV no
okay, TV way no yeah
live TV podcast of it's good say chief justice wanyantum people say na almost support. My point is that even though Emrem High Court back up any award divisions be, but can you imagine say a chief justice said jitum and uncle China another person in case on also so live telecast would the High Court do a war Ghana and then so be the all granting no be the one granting and then what happens and until that imagine say even though ebia omono fa ne say interest e was a case way but now wo share so I will set president bi abeto ho a there's no way na betimi adiso
okay
engineer say nka court bia high profile case because bia yenye live telecast I mean how you going to sustain this that asem no deep do na no emfa ye ni in the chiri enhwe stage ayedru
okay.
Now stage ye no critical because eno no ema ohu say ensem no bi ye tie wa abonten ensem no bi ye ka wa abonten and among our lawyers ni bi etu the impact on the substance of the case na nkasa etisen
okay
because we a criminal trial and it's a criminal trial no say ne embra no ahihye no state no and also mining in Ghana and then they will asem and it na ya na a republic versus Asumasi
okay
and specifically on this occasion a republic versus the first accused person Dr. Kessel ato Forson
okay
and the Japano the third accused person because second accused person no on health grounds na that we been to omo entire no prosecute
okay
and you no dey in film
okay
and the two accused persons we and omo ejina court
okay
omo de Ghana oman Ghana anya case okay na sane emra no etie no obi bia o say wo wadi boni bi e wo Ghana a boni no ya prescribe the punishment e wo mra kwan so e wo mram no say ye de e kwa akojina court na sa sendi bia asodie no eda oman no so say kwadu na ode abo no obekwa kofa ho adanse e de aba abe substantiate and as ode abe chirem adekodi anti a osusu say emra kwan so udi for because article 19(2)(c) of the constitution no as isudua say obi bia ye de criminal charge ebebo no you are presumed to be innocent until your guilt is proven or you plead guilty to the offense
okay
now guilty to the offense even a big crampo or o pleaded guilty mpo ambrano say and now the severity of the offense until pleaded guilty mpo you enter not guilty for you like murder or all those cases
okay.
And then on this occasion the once accused person pleaded not guilty no now state no ayo minor on this occasion no article 88 no so a attorney general and as asudi no eda no so and there was a attorney general epe adansefo a wo beba be gina mu abeka na asemama no say adekodi antia osusu say all the charges are the above any ingredients of every charge what you prove beyond reasonable doubt.
And it's up to the attorney general. No?
It's up to the attorney general.
No, who no ni ho. Also pardon for.
So now, the charge
okay.
And he who alleges must prove.
Okay.
It is all the be a court. When also compare dance for Babe Cansem no, Abe Chim, and they are dancing aba, and they are dancing biao, a dancing a jitum el quarter a ye. Admissible evidence.
Okay.
Because evidence in the her in the court of public opinion. To say me no ye can radio sooner or go say go for because na program bisona omo de sembi omo adwira gu ho sa no mkosa enema no bi e wo ho a empass admissibility test e wo court ejina bia na adekro no eye ade adanse bia nanka obi nyaaya kebe boa no pa but no behwe no na entumi pass the test of admissibility nti na ya admit
assembly nye untimi admit wo court
because admissibility no some bebre e wo ho but they be let's say for instance on this occasion so obekaya and see na wotwie ya na lawyers for the third accused person wo person wo tender a recorded conversation between Japa and the Attorney General. No. Now, Attorney General a raise objection. Objection Attorney General a raise and say, only a proper foundation for the tendering of that evidence.
Okay.
But of course, the court no overrules. And there be a foundation that only
you may be able to 1 to 2 years.
1 to 2 years. Echere se wo se court gitom ebi nso wo ho ana dipa no kra nkasa na ye gira nso attender sa evidence no wo nye the proper person and the proper party you bet me attender that document no and say that evidence through you and the other party will raise legal objection court no gitom I mean say won't me tender funny enough ebia na asend e bi e fa ansa se ho ne adade. So documents be our person or tender because the documents are related to land. Now a beer one stamp document no e wombra kwan so say ne was stamp no uti anye yia na court no not that we don't have the document not that document no enye relevant but a beer na one stamp
nyema beer also your one
precisely and the admissibility but about 10 there why dey kura wa e kire say o me dia be but we court no na ya anya ntum
court must make sure say everything about it what should be
asendie no abonten na ye ka no aya na ye simple ba ko e ba court every step of the way no ye were laws any procedures are regulate and you are na in substance no enka wo case bi na in terms of procedure no na de biario na ya bowaku enti na ya na omo de omo asem common lawyers lawyers no ya na bre no suppression no eso do no mama kan sam si de bi and the whole of endro anajo manda
the whole of last night
manda because na me prepare document bi and document no na was say send the tie bia bitimi wie enti no sa edu sa stage na wo da enye yi because o timeline bia what be the red ma we hu hwe enye yi enti no o client no wada o hu ne kromo anajo no na wo the whole night what why ebia na wo ye addresses and say submission and say whatever enti ni nyina e ka ho bi on this particular occasion say prosecution no de adansefo aba ama prosecution no abe prove the case ama prosecution wie the case no lawyers for the first accused person Dr. Kessben ato Forson and then lawyers for the third accused person Japano a application for no case to answer.
Okay.
And when the children say, Yadri yen say, Emra Kwanso, Susudiana Edahono. At the time our prosecution say we're close to the case, na Emra Kwanso on to mean establish their friend of prima facie case against the accused person.
Okay.
And then the children say, prosecution and dance here or their back court or they ebe prove case against ye ye the susudua no to ho ye gidi ye say want to me ampass it enti no ehun pon here say court be share ye say ye mebu defense.
Okay.
What am I saying? Enti no edru sa stage no na ebasana state no nso so aye nkrata OTM sehwe me emra kwan so no matimi aye I establish a substantive or prima facie case against you. And the rules are was a judge no transit. Now her evidence state ediaba or they ever proof the case against the accused person.
Okay.
No, I say a measure up to say Omo abuild the prima facie case if the answer is yes, then the judge will say you have a case to answer. If the answer is no, then it means at that stage you will be discharged, not acquitted.
You will be discharged
of those charges.
Mpacho, hold on now, Mimusa. Mti ebasana the conclusion lie with the judge.
Absolutely.
Say accuse you say the audience and the ban obian say judge and be decide say.
Absolutely, because who will say in our criminal jurisprudence, eba ascendi efa crime wonsema. Judge na odi asem no say enye trial on indictment na ye summary trial. Okay, my bitch. Trial on indictment no say the friend no simply jury trial.
Okay.
And no PS wo society public servants anyway ni akeka omo abo no more constitute the jury. Enti omo e be kwa akotena se omo ye trial of fact. Omo na ehwe asem no ma hwe say wudi fo ana say wudi bem. Na judge na wote ono ye trial of law no pronounce the verdict of the jury. And you trial on indictment like murder cases in those cases and no ya na do that stage a trial of fact the jury and the verdict but through the judge. But the best summary trial no judge and the trial of facts and the trial of law. And at that stage or no assessment say prosecution etymia proof a prima facie case against the accused persons now. And to be here a beba charge first charge who's the charges here na ebi endorse and you we na first charge judge wa assess no aka say charge we die evidence a prosecution there ba no matic a measure up so open your defense. Ebi a charge 2 ye hwe ye no na evidence na ye de aba no emu nhye da enye drusa enti no on that charge no ya discharge o. Enti na ebi a prosecution no be prosecute on ebi a 5 6 7 8 counts but ebi e be ba say at the stage na ye be application for submission of no case to answer no ye be wie that exercise no na ebi a count no a drop charges na drop it.
So be 8 be 5.
Precisely.
3 be afrim.
And on this occasion, at the time our prosecution we the case no. Lawyers near application for submission of no case to answer no. Judge no say look. Who the first accused person Dr. Kessben ato Forson. In the cross-examination of witnesses for the state, which is the prosecution, who put you across the theory of your case, say, or legal defense because you had authorization from the Ministry of Finance as a deputy minister to issue the LCs now authorization. Now, state in Asama or can say now we are deputy finance minister. Now we need authorization to have authorized the issuance of the LCs. I am so I ma ukuti as in respect of the ambulances.
Okay.
And in the judge no kind they say, look, accused person no say our authorization. It is our authorization a legal defense.
Okay.
So it is only fair say court no be ma kwenya na waba be establish wabe prove with evidence.
Okay.
Say na our authorization.
Until okase only authorization could have been different.
So okase only authorization and then what it means you say charging against you no technically no it's proven.
Okay.
And you know judge no fell say look it is fair to the accused person to be given opportunity to provide evidence to substantiate the claim say na our authorization.
Okay.
And the ato Forson across our line no when you kwenya testify he has been cross-examined. Witnesses or person of freewoman no when you kwenya afrewon ama won so testify they've been cross-examined by the state and I work close to the case. And as we speak Dr. Kesilato Forson were close to the case that other. Okay. Oba Jakwa Swa. Jakwa no also no court no ye say. No in the course of the theory of your case I will put you across no. They are all kind of say contrary to prosecution case say ambulances now what they buy no. You find say na akoy 207 or so whatever name you want to call it. Na enye fitted with the requisite equipment any materials I measure up to
an
ambulance.
Okay.
And I be boo and say ambulances. And you know what also financial loss to the state. And the Jakpa say no. Ambulances na ye de buy. There were issues na a war of fine say na at the time amoye we na ABI ye fitted with all the equipment but now you're taking steps ye making sure say you be install near fit the equipment be man about proper ambulances.
Okay.
And you know we have not caused financial loss to the state. Now the contracts now regulate the purchase of the ambulances no. And then cross to be woman the idea say who show me what in here ube who say me cause financial loss to the state.
Okay.
So the judge concluded at that stage say look Asama all can also raise legal defense. So there should be opportunity for Japas to also mount the witness box and also provide evidence to substantiate why he feels say on causing financial loss to the state.
Okay.
And when you say no, or no at a witness box ma. What can I say the friend evidence or not the evidence in Abba. Now he is being cross-examined. Now it drew say also a cross-examination. And a judge say in terms of sequence, the accused person, which is Dr. Kesilato Forson lawyers. And any kind and cross-examine Japan. No mujie state no so abe cross-examine. And the lawyers no. Yen de ebeya enkama state no ndi kan en cross examine no owie a yen be cross examine and a judge say look in terms of sequence mo na wose mo di kan cross examine mo wi na state na bam and mo call appeal say sa de no a judge na kan mo ne no nya adwen and mo apply for stay and of course that stay no judge no anyantum.
Okay.
And that is the stage where we are during cross examination of Japa by lawyers for Dr. Kesilato Forson and at this issue of the tape. It is always sequence. Now, in terms of the first accused person, Dr. Kesilato Forson, as far as the case is concerned, the case no we until say a beer or basic leave of the court. Say or sign akofa evidence fufuro bi abano or no the case where we no encounter ekoso or court to the side we need no at all.
Okay.
Now still now the Jakpati Adakama he's been cross-examined by lawyers for Dr. Kesilato Forson. And in the ekoso hono lawyers for Kesilato Forson cross-examine Japano na okeka nsem na okeka no and okofa tape we issue no ebae. Then you ask yourself say at the stage last 2 weeks or so ekofa broha has said because of the tape na aba bontin nti a man lawyers no ko file application for mistrial any dem na eka ho. Now lawyers for an accused person omo asudie a omo wo eni say obe make sure say to the best of their ability as lawyers omo provide the best defense that they can for their client, which is the accused person. And I was a back criminal trial. Yeah, na senka prosecution no de benya enka ya dino 10 because chana what I say prosecution no per se you didn't 10
assembly
free you be convict one ya convict you convict one ya but strategically, no, if you're a lawyer for an accused person, now the best that you can for your client. Also, so no embra kwan so no. Strategically, you say to the best of your ability. So bet to me, dear. Now call to the bema kwan. You because case no delay. It delays it's a news to the benefit of one of our clients who is the accused person. Because okay. A back criminal prosecution, the day of judgment, a accused person, no, the fate, the whole fate, and in a bush for fate, and a politician and a political party fate, and will judge them.
Okay. And what happened
that day? Say judge, you know, ebe trust in our accused person, you do kujina that come. Now judge, you know, a man verdict until say. Obey the words, you are hereby acquitted and discharged. The next idea I'll bet you say you are
okay.
Because once you are convicted, now you're sentenced so for custodial straight away, you don't track
okay.
So the point is that they now you command judgment, you know. So if you fear now court, now acquire and near mammy, either you come back home and celebrate, or you go to someone.
Okay.
So a serious something.
Okay.
And you are not sure because judge, you know, and no, I assess the evidence and all man the verdict. Until that day, you faith. Not in your lawyer's faith, but in the judge's hands.
Okay.
And until we a lawyer, that day no, say yeah, application or court. That court no anji and tuma. The albert sorry, I file books sometimes they be an judge no ruling now. I'm when in as the court pleases now pack your books now. Sorry, ako wako yeah so oh exceedingly grateful, my lord, I'm most grateful now when the but I don't know obia who enka because a application be now pay and farm a while. Prison.
Okay.
But back criminal case, the day I be my verdict, the lawyer no you don't consent woman be can say you don't worry, we'll appeal. But we'll appeal no. And only a years assembly e can you. Obe make effort, obey application for bail pending appeal. Ya grantee I would them.
That's with them.
Till so e be ko appeal. Then years assembly e can.
Wow.
And until we a lawyer, the best you can for an accused person, you are not sure what will happen, especially when we're crossing the line of you have a case to answer. When you do such stage now, the judge na can't what they say. Look, prosecution no to me establish a case against you. Explain to me why I should not sentence, convict, and jail you.
Okay.
Technically, that is why it means.
Okay.
And you not do that stage, a good day, a serious issue.
Okay.
And into who lawyer we are mindful of sad the best opportunity be obenya bia the case no delay at least so free fear court it's a your benefit. So omo ani abre omo ti ho twetwenti say omo nim say adenti na application for mistrial and for the court no master. So if you are in the shoes of a lawyer, one of them who defend an accused person, judge, you know, crossing the line of say, oh, case to answer. Every strategy that you can employ, you employ.
Okay.
Because ordinary, you know, Obian him say impose the application for mistrial court. Now court to the so then what? Because mistrial, no, apart from trial on indictment, a jury trial, mistrial in summary trials, no,
Embem
say and a bum crampo no enfan say technically for purposes of argument judge no so obegia to ma the legal effect no chese say.
Okay.
Mistrial legal effect and say you will be acquitted and discharged.
Meaning that substantive case in your account was some more close to
application for mistrial and court no say obejatuma. The legal effect no nkyere say ukofie asem no to atwa.
Okay.
Ne ekere ha ne say now charges no ye de ebo no ye drop it. Na ya assign prepare with the waba court back. Till ho you
charges na ye de ball
mistrial application no enkyere say se court no mpo se obeji atomu a enkyere say charges na ye de ball the whole case na dwiragu because mistrial no the ekere no say e was say sign prepare sign the asam no ekoko to biem
okay
the sign ko shase
ti esa ko shase
precisely. So my point is that application for mistrial and crofo press conference or when you are brilliant simple judge because the legal foundation for mistrial is subject trial a BAD hosa in that part of the world. A trial on indictment and I am a mistrial. To say typical example Bolafuku the brother the case Gregory Afuku who say at the end of the case jury no any of verdict buy no omo say conspiracy charge no omo the other person no guilty and away until like based on that no ambassador boy declare mistrial. The bad mistrial no pay what the means to say say omo say prepare about the third time omo sign the court which for the lawyers think for we no rem say still na the papa no ye try no but mistrial and just say just that's what I'm saying. So
maybe I build a yes, I'm
so now mistrial application the whole way for the public very interesting yeah but legally technically na enchire process and kajaje no beja tuma case no to atwa afi na nanka ye be say abesha ase wow but the fair no to che at the end of the judge na ja to because so say legal obia man legal foundation bia in our law I say subject trial no the basis for mistrial na existed there was none enobogu ye okay in the case air to us but uzo mo file application for mistrial no omo attach the evidence of the record the audio evidence and I judge the way na say okay in terms of the evidence now what audio no so establishes that there was a conversation between the third accused person and the attorney general and all that but as far as on no you're concerned the substance of their conversation on the case na kasa I won and him no where it is what I say okay but now what she their assign kofa case number and say lawyers no say yes okay in the case na kasaro just give me a second.
All right good morning my main kind message so enough yentwaso Musa Abato was say the judge's decision to admit the leak tape where the Attorney General was coercing Richard Jakpa to implicate Ato Forson in the ambulance case is a commendable step towards justice and transparency. This move sheds light on the unfortunate conduct of President Akufo-Addo and then Finance Minister Ken Ofori-Atta, who were reportedly pressuring AG Godfrey Dami to use legal maneuvers to unjustly imprison Ato Forson. It underscores the critical importance of an independent jury in upholding the rule of law against political machinations.
And we a trial in the court of public opinion.
Yeah.
But when you call the substance of the case na kasadia, ube bisa say sa conversation na a what tape no so no so far as a sample enetia eno no in the case na kasa e wo court no e ho enchance an etisen the impact on the case na kasa no etisen
okay
you understand my point judge na oti ho no or he say charge na ye de ball wo no ingredients of each charge, because charge be our ingredients I was a prosecution proof.
Okay.
Ingredients of each charge in a prosecution no at me approval. Now to the extent say ya cross submission of no case to answer line, no bet me can say judge no at that stage in Nigeria to prosecution now establish prima facie case.
Okay.
And you know what is being done now is for the accused persons to explain why they are not guilty.
Okay.
And then the air course now because the prosecution are really in the case, and a conversation now a course one. The amount for also much of my being one say whatever conversation are on the audio. A conversation attorney general as the original state and a prosecute and on a Japanese conversation.
Okay.
As to whether say and no what any impact on the case itself, legally something that straight sir, because so be born chimpo say or record or was send ya obekan nsem ema na asisi so because ono na or record and onim dia opese ode enti no ebia na won kan no no anka say ka say wo say me say wo say and I will say the fact say I'm free man no enche say me na maka but on the tape no bet so and I opese me ye say me gidi ye say me nya guilty now the fact say accused person bia ka say ono susu say onya guilty in interest onya guilty.
Okay.
That's the point I want to state.
Okay.
The fact impo say yem fan say attorney general mpo ka say osusu say as an agent as a business person, you know. And can this say you try wa and no say judge, you know, any evidence before the court known to me and establish say we are guilty.
Okay.
Because the moment a judge say my access evidence, I think said there's a prima facie case for you to answer no. Such issue as to whether say attorney general na nkasa no kra belief no as far as your prosecution is concerned no immaterial at this stage.
Okay.
Because at this stage it is the judge who determines evidence the abred weight will be attached. For instance the LC's interpretation and not jack panone attorney general we can say we candidate interpretation no as far as the judge is concerned no on the whole final say.
Okay.
Interpretation and judge no the better so any weight will be attached to sa document ebe impact on the decision.
Okay.
It doesn't matter the belief of attorney general and the belief of the accused person.
Okay.
And then I make say admission of this audio recording no impact on the substantive case itself. Ebia na ubehwe no na ensheda enye adebia emu edrubia because
so try judge no eji or can say for fairness sake.
Of course.
And no chasing.
No, of course. They all kind of say no. They all kind of say so now also person tender audio recording. Okay. And on one can say senka a state no and a person tender audio recording say yeah electronic recording na obeja to my who why about we no dey and objection now we no raise here no so na ogina ya or share ya or they admit it.
Okay.
Don't forget say the last time our man ruling no or advice say the attorney general says enkebe ya enka ontwene ho and I think say as lawyers in this case attorney general na a lawyer because na original Ghana name normally we take a cue from the bench. Yes you asema judge no aka no ebi mpo ananka omba so my lord I'll take a cue from the bench. Me if Semena me too go for dame for I will advise him to take a cue from the bench.
Okay.
Because you have a witness out adakama state no nyam cross examine japa. Now what is happening in court no lawyers for case they are to Forson and or more cross examine japa. And when yes I will elicit positive evidence to support the theory of your case. State enyam cross examine japa to confront him with even what is on the tape. We are not there in law. And then say, "Oh, attorney general no na one na obeba say Drew say was a state be cross examination. That one na ube jina ho across examine no. You see the drama and all that theatrics na beba. And say judge no say of you say enkatwe wo ho a menyi ni yesef in the interest of because why and there's President Kufuor decided say attorney general warisha phone does it mean that the case will end? No.
Okay.
The case is not a case between Godfrey Dame as an individual and Japa. That's why people are making a mistake.
Okay.
Attorney General is Attorney General because he's a lawyer for the state now that he's the Attorney General. That is how it ends. Attorney General can be reshuffled tomorrow and the case will continue.
Okay.
Attorney General can be sacked tomorrow and the case will not end because Godfrey Dame is no longer the Attorney General. The case will progress, it will proceed. Unless Attorney General Fufrobi Obababe decided say ebia or internally prosecute. Say case no class state no any interested in the case will progress. And then say who ni ho say who na Obababe General personally. Now cross examine Japan. Does it mean say the case cannot go on?
All right.
There are other lawyers within the Attorney General setup. Chiaye Buano, who's the Deputy Attorney General, other Ubuabasada, people who are there on your prosecution.
Okay.
It doesn't mean that who knew our state cannot prosecute the case.
Okay.
And it mean my dream say would have taken a cue from the bench.
Okay.
Now, corona baby. Now. We not so, but if still is fine, it will be drama. Anybody who is like a movie who enjoy the encounter between the Attorney General and Japa as far as this equal. But there may person me can say once out here and grow for draw more conclusions based on your recording. So my point is that let's be measured because near what tape no so no what conversation between Attorney General and Japa. As to the impact
on the
case itself, no, untumi and draw any conclusion.
Okay.
Squarely, no, it is the judge who will determine at the end of the case, say, accused persons, no, omo guilty, and I say omo guilty, based on evidence before her.
Okay.
Based on evidence before her.
Okay.
Based on evidence on record before her. Not Niayeka or Kessben television. Not Niayeka or Kessben radio. Not Niaya Tessie radio so Ediako. That will not have any impact on judging decision. Purely a judge is some share we are not a cover or masono. A judge na so asisi. Niayeka or radio so Niayeka or TV so any impact or money judgment based on evidence on record before her and obey assessment will determine the fate of the accused persons. That is the point I'm a person put to across.
All right. There is this way, especially from the NDC camp, Kase Ebeyanka on resign and a lot of other opinion lead and as a more can be a woman. I think Ebeyanka Attorney General and resign and free the position because we're compromising the position.
Well, me resignation there. I mean, fine, say resignation there. Yeah, it be there. So we resign. Bia say obia. Obia, bia, and Kobeka say, and nam we impo resign.
Okay.
But so there no eto ho say because of say bia because so also be komua. Me nti na make say also ube komua. Now we are fair to facts surround this idea. The same people beba.
Right.
Because enti na jakwa no ebo ni trimpo say obe record Attorney General for what purpose?
Okay.
Now babon thing say na Attorney General no ya affidavit na mo kan say it was at the instant of who jakwa and a man Supreme Court judge be on your behalf.
A call it that meeting.
For Dame, I would decide say obe engage. Publicly, so Attorney General Fona can say on record there was an attempt by Wujakwe say obeye a plea bargaining. I bema sa company na winning the deal I na been so bet yes can na nka yenya asem no. Attorney General ejina na so can say sa company no enye accused person before the court. And plea bargaining arrangement can only be entered between an accused person and the state. Enti munko na munko tron ye enfambra. And that is a no nana aye back and forth omo di ho enkomo na mo copy Supreme Court judge. So people have also said so when the Supreme Court judge no or no so cry on resign and all that. I'm saying say let's be measured in where I this idea we echo because say obi a recorder then out here say my echo fine it's drama and we are enjoying it.
Yeah.
My point is that on the day of reckoning, which is the day of judgment.
When you know
And yet can radio so and the press conferences are Ghana.
Okay.
Purely no about assessment of evidence on record.
Okay.
And a judge no be jinaswa or the bemani decision.
All right.
And this audio recording now about bonting no at this stage premature say obia be jina no so aka say because of that case no ko say na say ekose. That is the notion I'm a say you dispel from our minds.
All right.
Because that is not what criminal prosecution is here.
All right. Like every team I'm saying something can be but